Less than a month before jury selection begins, the father of the Oxford school shooter wants his trial moved out of Oakland County, but the prosecution is urging the judge to deny that request. Attorneys for James Crumbley say that all the media attention surrounding his wife's case will make it difficult to find an impartial jury. The prosecution says while there is a large number of people affected, it doesn't prevent Crumbley from receiving a fair and impartial jury like his wife did. All right, let's talk about it with former federal prosecutor Rick Convertino. Rick, thank you for being here with us.
Hi, Terrence. How are you?
Doing well. So what do you make of this request? You know, we had been watching that trial for Jennifer, wondering if his team would try to make a move based on what happened there. Do you think that this is just a way for him to try his best to get out of the same fate that she had?
Well, I think it's a feckless attempt. That ship has sailed. About 18 months ago, this has already been addressed by the judge. Initially, a change of venue was attempted. The judge denied the change of venue, and so to relitigate this at this point, I think is fruitless. It's going to get him nowhere.
And do you think that it's even really a good thing to try to do because Oakland County is so affected by this case? What does that look like to the public, in your opinion?
Well, the test is it has to be an inflammatory. The publicity has to be so outrageously pervasive that it inflames the passions of a potential jury pool. Now, the voir dire in this case has been extensive. In the first trial and Jennifer Crumbley's trial, the jury was picked relatively fast. I thought it would take about 2 weeks to pick. I think it was a couple of days to pick a jury in that case. And so I think the judge believes, at least in Jennifer Crumbley's case, that it was more than possible, in fact, likely, that they can get a fair and impartial jury. In this case, I think it's in similar standing. I don't think that the publicity of the trial and the pretrial, which has been ubiquitous, is still so inflammatory and littered with untruths and falsehoods that it would inflame and impassion a potential juror. That can be handled in voir dire through questions and answers by both parties, including the judge. So I don't think this motion is going anywhere. I think it's kind of a pro forma thing. The likelihood 1 month before trial, the judge granting a change of venue is zero.
Yeah. And, this case is one that really affected people across the country, really around the world. People have heard of this. So considering that, how effective do you think this strategy is on behalf of his team? Because it'd be hard to find anyone who has not heard at least something about this case.
Well, you're right, Terrence, but that's not the standard, whether somebody heard about the case or not. You'd be hard pressed to find any potential juror who's going to be seated on March 5th that doesn't have some kind of knowledge about the case. But the question is whether or not they can put aside whatever they have or predetermined biases and render a fair and impartial verdict based upon the facts as presented by the case. I mean, that goes back, the history of a fair and impartial jury goes back before this country was formed. You may recall the Boston Massacre in 1770, March of 1770. There you had British soldiers shooting and killing what was then, pre-American citizens, colonials. And they were arrested. The soldiers, the British soldiers, were arrested and indicted, and their juries were going to be the colonial Americans that were essentially determined to rid them of what became the United States, the British soldiers. In that case, John Adams, who became president, represented the British soldiers, and the jurors were the citizens who, some of who were shot upon. And in that case, John Adams got the British soldiers acquitted. So this tradition of fair and impartiality and whether or not potential jurors could put aside their predetermined prejudices and biases and listen to the facts rendered from the jury box and consider the evidence as it's presented in court is one that we take great pride in this country. And I think certainly the Oakland County jurors, potential jurors, will do the very same thing they did in the previous trial and all trials in Oakland County and all across the country.
And
Fair and impartiality is the goal.
lastly, on this topic, Rick, with Jennifer's trial, there were a lot of people who went into it really unsure of what the outcome would be. Do you think that guilty verdict sent his legal team scrambling a little bit?
Well, they should be scrambling a lot of it because the facts are horrible for him, and they were for Jennifer Crumbley, and so I mean, it doesn't have to do with the potential jury pool. It has to do with the facts and the evidence in the case against James Crumbley. I mean, it certainly was abundantly clear from the evidence presented in Jennifer Crumbley's case that they were aware that their child had severe mental illness and was progressing from March and April all the way to the time of the shooting, and they kept their head in the sand and ignored what they could have done and should have done, which is take ordinary care to prevent this horrific tragedy from occurring. It was instead what they did was they went out 3 days before the shooting and they purchased him a 9mm gun, took him to the gun range, let him practice, and ignored all the overwhelming warning signs that were right in front of their face.
Yeah, very unfortunate set of circumstances. Let's move on to Donald Trump. We know that New York judge has ruled that the former president and his co-defendants paid $350 million in that civil fraud case. What do you make of that?
Yeah, it's extraordinary. I mean, the attorney general is asking for $370 million. The disgorgement that was awarded was $355 million, plus $8 million for Trump's kids, Eric and Don Jr., plus $100 million in rolling interest. And I went back and I looked at all the cases that the former president was facing and faced. He had in the verdicts that he had, in the settlements that he had $25 million fraud settlement disgorgement in the Trump University case. He had a $5 million jury award in the E.G. Carroll first trial, then an $87 million jury verdict award in the E.G. Carroll second trial. Then he had the fraud that was related to the Trump Foundation and the Trump charities that amounted to another $2 million. So all told, at this point in time, Donald Trump is facing $490 million in disgorgement, fines, and sanctions based upon jury trials and verdicts and settlements just in the last couple years. So this is monumental. The judge made a painstakingly fact-related credibility findings. He said that Donald Trump had zero credibility as a witness. Said that the expert who was paid $1 million on behalf of Donald Trump to testify that the books and records were properly used according to generally accounted accounting principles and practices. The judge found that expert had zero credibility. The Trump children who testified at the trial, the judge also found that they had zero credibility. Now, this is important. Credibility issues are important for the finder of fact, in this case, Judge Engron, because it makes it much more difficult for an appellate court to overrule those issues of credibility. Appellate courts give great weight to the credibility determinations made by the trier of fact or the judge. And most importantly, in this case, and it's on page 41 through 43 of the opinion, Judge Engron made a specific note that Michael Cohen, who was initially a Trump employee and the one who came forward with the allegations against Donald Trump in the congressional hearings, was a very credible witness. So these findings that the judge made were critically important for the purposes of protecting this order on appeal.
And we'll be watching both of these cases very closely. Rick, as always, thank you for your time.
Thanks, Terrence.